513 discusses the psychotherapist patient privilege and is one of the most important privileges for a survivor. The 513 privilege states that a patient has the privilege to refuse to disclose and to prevent any other person from disclosing a confidential communication made between the patient and the psychotherapist if the communication was made for the purpose of facilitating diagnosis or treatment of the patient's mental or emotional condition. This applies to mental health records, not medical records. You can use Article 6B and other privacy rights to try to argue that certain medical records should not be disclosed. However, there's not a specific privilege that prevents disclosure of medical records. A party seeking production or admission of records or communications that are protected by the 513 privilege must show by a preponderance of the evidence 4 separate things. 1, they must show a specific, credible, factual basis that the records or communications sought would likely contain or lead to the discovery of evidence admissible under an exception to the rule. 2, they must show that the requested information meets one of the enumerated exceptions to the privilege, or that it is constitutionally required. We won't go through the exceptions today, but they are listed in MRE 513. 3, the person must show that the information sought is not merely cumulative of other information that is available. And finally, 4, the party must show that they made reasonable efforts to obtain the same or substantially similar information through non-privileged sources. If a party meets their 513 burden, then the judge may review the evidence in camera, and only then can the judge decide whether some or all of the evidence should be disclosed. Any production or disclosure that the judge permits must be narrowly tailored to only the specific records or communications or portions of such records or communications that meet the requirements of one of the enumerated exceptions to the privilege. While being constitutionally required is not technically an enumerated exception to the privilege, it is one that always exists. And so if the disclosure is constitutionally required, then the judge will likely grant it. In practice, this means that the defense attorneys will try to seek a victim's mental health records, including statements made during therapy sessions, diagnoses, and prescription information for a number of reasons. These may include, 1, trying to find a prior inconsistent statement that a victim made to her therapist about the assault. 2, they may try to use a diagnosis to suggest that the victim is lying or hallucinating or engaging in what they call attention-seeking behaviors caused by the diagnosis. So for example, if someone had a personality disorder, they would claim that that disorder may suggest that the person is lying, hallucinating, or engaging in attention-seeking behavior. 3, defense counsel may try to use prescription information to suggest that the victim's medications impacted her memory or her ability to perceive on the night of the assault, or even on days where she was interviewed about the assault thereafter. For example, if an assault occurred while a victim was intoxicated, the defense may seek to discover whether the victim was prescribed antidepressants, for example, at the time of the assault. And they would argue, potentially, that mixing antidepressants and alcohol can have side effects of causing hallucinations or an inability to perceive events accurately. This could cause them to ask the court to disclose those privileged records or communications showing such statements, prescriptions, or diagnoses. Next, we'll discuss the scope of the 513 privilege. The Navy and Marine Corps, Coast Guard, and Army have all weighed in on what they think is the proper scope of the privilege. This means what is privileged under 513 and what is not privileged under 513. The recently decided Millett case for the Navy and the Marine Corps stated that this privilege should be protected to the greatest extent possible. They said that a patient's description of her symptoms, as well as the psychotherapist's diagnosis and treatment plan, should all be considered privileged under 513. This includes prescriptions of medications as well. They stated that the privilege extends to communications between the patient and her psychotherapist, and that it's not just a one-way street. They use the statutory language in 513 to make this assessment. The Coast Guard, on the other hand, had a slightly more narrowed view of the scope of the 513 privilege. In the Kitchen case, the Coast Guard stated that there are several things that are privileged under 513. This includes diagnosis, the date of diagnosis, medications that were prescribed, the duration the medications were to be taken, any therapies used, and the resolution of the individual's condition. However, they stated that some things are not privileged and did not fall under 513, and therefore did not have to endure the 513 analysis in order to be disclosed. Those items are dates of treatment, identity of the provider, and length of each appointment. Those they considered not privileged. The Army, in the Rodriguez case, had the most narrowed view of the scope of the 513 privilege. They stated that the only things that are privileged under 513 are statements and records that reveal the substance of conversations that are for the purpose of facilitating diagnosis or treatment. This would basically mean that anything that is communicated directly between the individual and the psychotherapist, such as therapy notes, are the only things that are really privileged. What's not privileged is the diagnosis itself or the treatment that was prescribed by the psychotherapist. It is important to note that the 513 privilege can be waived along with other privileges. And a privilege is waived when the holder of the privilege voluntarily discloses or consents to disclosure of any significant part of the matter or communication under such circumstances that it would be inappropriate to allow the claim of privilege.